How does the military justice system interact with civilian divorce courts? Have you ever wondered how divorce works when one or both partners are in the military? It can be a bit tricky, so let's break it down. The military justice system does not handle divorce cases directly. Instead, these cases are managed in civilian courts, following state law. Military courts, which operate under the Uniform Code of Military Justice, do not have authority over divorce matters. However, military legal personnel, known as Judge Advocate General officers, can offer legal advice and help with paperwork. They can notarize documents and assist with administrative tasks, but they cannot representing service members in civilian divorce courts. When it comes to divorce cases involving military members, both state family law and specific federal laws come into play. One important federal law is the Servicemembers Civil Relief Act. This law protects active duty service members by allowing them to postpone divorce proceedings if their military duties prevent them from participating in court. This postponement can last for the duration of their active service, plus an additional period, usually up to 60 or 90 days after they leave service. This ensures that military obligations do not unfairly affect the divorce process. Another key federal law is the Uniformed Services Former Spouses Protection Act. This law governs how military retirement benefits are divided during a divorce. Unlike civilian pensions, military retirement pay can only be divided if the marriage lasted at least 10 years, while the service member was on active duty. This federal law works alongside state property division laws to determine how military pensions and benefits are shared between spouses. Jurisdiction can be complicated in military divorces. Military couples often live in different states or even countries due to deployments. A divorce can be filed in the state where either spouse lives, where the military member is stationed, or where the military member maintains legal residency. State courts will apply their family law rules for custody, child support, spousal support, and property division, but they must also consider the unique circumstances of military service. Child and spousal support calculations may also be influenced by military pay and allowances. Some states limit support to a certain percentage of the military member's pay and benefits. The military has strict rules to ensure timely payment of court-ordered support. If a service member fails to comply, they could face military disciplinary action. In summary, while the military justice system does not directly handle divorces, it interacts with civilian divorce courts through federal laws that protect service members' rights. These laws address military-specific issues like deployment delays, pension division, and support obligations. Civilian courts remains the venue for divorce, but they must consider these military aspects to fairly resolve cases involving military personnel. This interaction creates additional legal layers and protections that make military divorces distinct from civilian ones.